So the Texas Suppressor lawsuit, which seeks to stop the NFA and ATF's regulation of suppressors, has now been set for a trial. So let's talk about this. But real quick before we jump into this video, if you think the NFA and the GCA need to be done away with, go ahead and hit that like button and subscribe. So like I said in the intro, the Texas Suppressor Freedom lawsuit, which aims to eliminate the NFA and ATF's regulation of suppressors, has now been set for a trial. Recently, we discussed how the ATF was doubling down to get this Texas Suppressor Freedom lawsuit completely thrown out by the judge in this case because they claim that suppressors are not protected under the Second Amendment, or they're not protected or affected at all by the Supreme Court's recent ruling in New York State Rifle and Pistol Association v. Bruen. The ATF is currently seeking to have this case completely dismissed by the court, and even wrote in their recent reply that the recent Supreme Court decision in Bruen has no impact on the agency's authority to regulate suppressors and other items under the NFA. Now, if you're not aware what this lawsuit entails, this case arises out of Texas House Bill 957, which passed last year. HB 957 aimed to exempt from federal regulation all suppressors that are made and remain in the state of Texas. The law that Texas passed last year requires that these made in Texas suppressors be stamped made in Texas, and it bars all local agencies and entities from enforcing inconsistent federal laws against Texas residents or manufacturers of these items who manufacture them, or residents who purchase these items that are made in Texas. The claim behind this law is that since these items are made and sold exclusively within the state of Texas, it does not impact interstate commerce, and therefore this whole law and these types of suppressors fall outside of the purview of federal regulation by the ATF. After Texas passed this law last year, the ATF then sent out a letter essentially to all FFLs and all individuals within the state of Texas, threatening that the ATF will in fact enforce the NFA and GCA's regulation of these items against anyone who possesses, manufactures, buys, sells, transports any of these made in Texas suppressors. After the ATF sent out that warning letter to all residents within the state of Texas, the state of Texas, through their attorney general, filed a lawsuit on behalf of individual Texas plaintiffs against the ATF. In response to this lawsuit, which was filed by the state of Texas against the ATF then filed an original motion to dismiss the case. A motion to dismiss is simply a legal mechanism where either side can seek to have the case thrown out, and the court decides whether or not there are merits for the case to be ultimately dismissed. Subsequent to that motion to dismiss, the state of Texas filed their first amended complaint and then asked the court to find that the motion to dismiss was moot, which ultimately the court there did find that that whole motion to dismiss by the ATF was moot. And now the state of Texas has also filed a second amended complaint, and this amended complaint added in strong Second Amendment arguments because of the Supreme Court's recent ruling in New York State Rifle and Pistol Association v. Bruen. Under the Bruen framework, the state of Texas is arguing that the ATF cannot prove that their regulation of made in Texas suppressors has any basis in history or tradition of the Second Amendment dating back to 1791. That is the standard that was outlined in Bruen. And because of this amended complaint, the ATF has now filed for a second motion to dismiss. This is a new motion to dismiss. And essentially they walk through a new strategy which argues that the Second Amendment is not implicated whatsoever in this case. And also they argue that suppressors are not bearable arms, and therefore they are not protected by the Second Amendment, and they are not protected from regulation by the ATF. One of the main reasons the ATF claims that this case needs to be dismissed is because they claim that suppressors are not bearable arms within the meaning of the Second Amendment. The ATF claims that Texas has the burden of proving certainty of success on the merits based on the information available at this time. The ATF argues that Texas has not come close to meeting that high threshold for several reasons. First, they argue that unanimous precedent holds that the Second Amendment does not apply to suppressors based on the text and history of the Second Amendment. Again, they're arguing that suppressors as an item fall outside of the protection of the text of the Second Amendment. The ATF also claims that nothing in the Bruen decision has brought any of this argument or any of the prior precedent into question in regards to suppressors not being protected by the Second Amendment. They are arguing that there is some sort of precedent that would say that suppressors are not protected by the Second Amendment, and they're saying that Bruen doesn't bring any of that into question. But then the ATF goes on later to concede that the NFA and the tax power of the NFA has not been reanalyzed yet using Bruen. However, the ATF argues any question about whether Bruen alters the current NFA precedent is debatable at best, they argue. So the ATF concedes that the NFA has not been re-challenged under Bruin, has not been re-looked at under Bruin, but they're saying none of that matters, that Bruin will not impact this issue whatsoever. But we all know that the Bruin decision will likely impact the NFA and will likely change a lot in regards to the NFA and the ATF's regulation of various items. Then the ATF doubles down on their argument that these are not bearable arms akin to firearms, despite the fact that the ATF itself actually treats these suppressors, these silencers, these items, and regulates them as actual firearms. They treat them as bearable arms. As we all know, the NFA and the ATF claim that they have authority to regulate suppressors and the making of suppressors because they claim under the definition that these items are actually firearms. And in the same brief where they are arguing that these are not bearable arms, they also go on to also say that they have the authority to regulate suppressors because they are firearms, and they walk out that definition of suppressors as firearms. So they're trying to have their cake and eat it too. At one point, they are arguing that these are not bearable arms, that these are not firearms, that they are not protected by the Second Amendment. But then on the other side of it, whenever it's most beneficial to them, they're saying, yes, these are bearable arms, yes, these are firearms, and we have the power to regulate them. So the battle right now in this case is the ATF trying to get this case dismissed right here and now, and the state of Texas simply wants this case to proceed forward to a trial so that the court can actually look at this issue. Recently, we had an update that the court has issued a scheduling order for this whole Texas suppressor freedom lawsuit. Tentatively, the case is currently set for trial on November 13th of next year. That is when the court has set trial for this case. That's when this whole issue will be finally heard. Now, some have been asking me in regards to this update whether or not the ATF's motion to dismiss the case has been denied by the court because the court is setting a trial for this case. The answer to that is no. The court still needs to rule on whether or not they're going to grant or deny the motion to dismiss. If the court denies the motion, then the case will proceed forward to that trial date. However, if the court does grant the ATF motion, that will essentially mean that this case is resolved kind of at this moment. The ATF will essentially have won at that point. Now, that doesn't mean that this case is completely done there. At that point, there will likely be an appeal. Whether or not the motion to dismiss is granted or denied, I would fully suspect that this might not even reach a final trial anytime soon. I would suspect, based on this motion to dismiss, there will be an appeal up to the Circuit Court, the Fifth Circuit Court of Appeals. And the issue that will likely make its way up to the Fifth Circuit is whether or not the lower court here was correct in granting or denying that motion to dismiss. That's likely going to be where I see this case going. It's likely going to make its way up to the Fifth Circuit. And really, that's kind of where we want this case to go. We want it to get elevated to the appeals court, maybe even eventually up to the SCOTUS, up to a higher court that can evaluate the merits of the NFA and also the ATF's regulatory authority using that recent New York State Rifle and Pistol Association v. Bruin standard. Now, currently, there are two other cases that are up at the Supreme Court level which challenge the ATF's regulatory authority. And specifically, those are the Aposhian case and the GOA case, which challenge the ATF's regulation of bump stocks. Those two cases are at the Supreme Court level. They have been distributed for Supreme Court conference on the 28th of this month. So depending on what the Supreme Court does with those cases, that could also really set the groundwork for where this specific case will go from here, and also other cases which challenge the ATF's regulatory authority. So that's where the suppressor freedom lawsuit currently stands. Like I said, we will definitely be keeping our eyes on this case to see where it goes from here. And I know a lot of you guys were confused about the trial being set and what happened with the whole motion to dismiss. We still suspect that the motion to dismiss will need to be ruled on by the judge. And then I suspect after that, then there will be an appeal up to the Fifth Circuit. But we'll definitely be keeping our eyes on this case. If you guys have any questions, go ahead and comment down below and I'll try to answer best of my ability. Also, if you like this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet and signal to YouTube that you guys see value in these videos and in this type of two-way news. Again, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So again, thank you so much for all of your support. And as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this is Built by Armed Scholars, and this nation will be maintained by Armed Scholars.